Good day, everyone. This is Operation Investigation, Part 2 topic, which covered the custodial investigation. So, the first is the duties of the police during custodial investigation. This is under the Republic Act 7438, Section 2. So, for the arresting officer or the investigator, as the case may be, shall ensure that a person arrested, detained, or under custodial investigation shall be at all times be assisted by the counsel, of course, preferably of his or his own choice. This is to ensure that they build a good communication and to ensure that everything goes well. For number two, the arresting officer or the investigator, as the case may be, must inform the person arrested, detained, or under custodial investigation of the following rights that is under the Republic Act 7438 and Republic Act 9745 in a language or dialect known to and understood by him or her. This is to inform of their Miranda rights. So here it is. He or she has the right to remain silent. If he waives his or her right to remain silent, anything he says can be used against him under the court of law. Letter B. He has the right to an attorney or to his own counsel, preferably of his own choice. If he cannot provide one will be provided for him, for her, that he is under the public attorney's office. For letter C, he has the right to demand physical examination by an independent and competent doctor of his or her own choice before and after interview or questioning. This is to ensure that no harm was done during the investigation. If the person arrested is a female, she shall be provided by or attended by a female doctor, of course. If she cannot afford one will be provided for her or him. Letter D. The state shall endeavor to provide him or her with physiological evaluation if available under the circumstances. This is in particular to those with mental illnesses, those which are studying with mental illnesses. Letter E. He, she, including his or her immediate family, has the right to immediate access to proper and adequate medical treatment, especially those with physical injuries, cases with physical injuries. And letter F, he, she has the right to be informed of all his rights or such rights. Okay, this is in connection to those cases that had been violated, which had violated their human rights. Okay, for number 3, if the person arrested, detained, or under custodial investigation opted to give a sworn statement, which is stated in the Annex PP, the arresting officer or the investigator, as the case may be, must reduce it in writing and in the presence of his or her counsel. This is to ensure that all the things that were said were can be used against him, especially if it connects the crimes to his crimes. Also, with the presence of his counsel, of course, to ensure that he or she witnessed everything the person or the person arrested had said. The arresting officer must ensure that before the sworn statement is signed or thumb marked, if there is an inability to read and to write, the document shall be read and adequately explained to the person arrested, detained, or under custodial investigation by his or her counsel of choice, or by the assisting counsel provided to him or her in the language or dialect known to her. So before giving the sworn statement or before thumb marking or signing the sworn document, it should be ensured to the person arrested that he or she understood what was contained in the document. This is to ensure that before giving this statement, he understood what he or she is saying or what is covered in the sworn statement. Number 5, the arresting officer or the investigator, as the case may be, must ensure that any extrajudicial confession made by the person arrested, detained, or under custodial investigation shall be in writing. This is to ensure that they will not go back with words that they said during the sworn statement or during the giving of the sworn statement. Letter B, it is signed by such person in the presence of his or her own counsel. Of course, it was signed by the person after giving the statement by the presence of his attorney or her attorney. And then in the letter's absence upon a valid waiver and in the presence of any of the persons, the name of parents, elder brothers, or immediate family, or any respected person if the counsel or the attorney was absent during the giving of the sworn statement of the arrested person. This is to ensure that they could stand the information they had given. Okay, in the failure of the arresting officer or the investigator in observing the above mentioned procedures, which was rendered, shall render the extrajudicial confession inadmissible under the court of law. So, if the counsel was absent and there is no witness or even a respected person present to witness what the arrested officer had said, then the sworn statement or what was written in the sworn statement or the extrajudicial confession shall be inadmissible since it could be termed as um, illegally confessed because of there's no presence of the counsel. So that is for letter A, which is the duties of the police during custodial investigation. So for letter B is the person under police custody or the PUPC. So the following are the policies and procedures in the admission, visitation, and transfer and release of persons under police custody, which was written under PNP Memorandum Circular 2018-027. So, number 1 is admission. So, the pertinent data of the person under police custody shall be encoded in the electronic rogues or e-rogues and other NGIS as applicable. So, the following can be detained admitted in PNP custodial facilities. Letter E is the accused covered by a warrant of arrest or a commitment order issued by the court. So, a person can be detained only in PNP custodial facilities if he had a warrant or of arrest or a commitment order issued by the court. So letter B, arrested suspects who are under custodial investigation. However, under no circumstances should the arrested suspect under custodial investigation be held in custodial facilities beyond the prescribed reglementary period unless while in custody appropriate charges had been filed and commitment order have been issued by the court concerned or he she is signed the required waiver of the rights under the provision of Article 125 of the RPC. So, suspects which should be detained or who are under custodial investigation should be held in the PNP custodial facilities. However, the arrested suspects under custodial investigation should not be held beyond the prescribed reglementary period. So this is in particular to those if the person arrested had no warrant of arrest within the reglementary period, they should be free. They should be free or they should be released unless when they are in the police custody and the warrant of arrest was released, then they should be maintained or detained there. Okay, so number one is admission. For number two is the requirements for admission. So before admitting, here are the requirements. In a situation where the arresting police unit has no existing custodial facility, they may request admission of the person under police custody to another police unit provided that they submit the following mandatory requirements. So if the police unit had no custodial facility, they could request admission of the person to another police unit who had available existing or who had existing custodial facility. So here are the following mandatory requirements. Filter is request for custody or commitment order. So you should request first is the custody for the transfer of the arrested person. Let there be proof of medical examination or medical certificate of the person under police custody. So this is important because this could lead to another case, especially those who had been transferred and then they receive maltreatment. Then that could be used as a case to file a case to that unit where the person where the arrested person was transferred. Okay, and letter C, case holder of the police under um person under police custody containing among others the accomplishment booking set. So they should turn over all the files of the person arrested to um the police unit where they plan to transfer the arrested person. So we have here number three is segregation of PUPC, or PUPC or person under police investigation. Segregation according to gender in classification of crimes committed by person under police investigation shall be observed. So they should be segregated or they should be placed in another um, custodial facility which is iba sa mga dating nandun or iba sa mga nandun na naaresto ng unit na pinag-transferan sa kanila. This is to ensure that they are safe, and then this is to easily identify that they are transferred persons from another unit. Number four is visitation. We have here the visitorial rights of the person under police custody shall be subject to the following conditions, which is letter A, security rules and regulations of the facility such as but not limited to. Number one, the number of visitors at any given time. So there are given numbers of visitors to visit the arrested or detained person. Non-wearing of similar color with the PUPCO uniform. Of course, you should wear something more different. Example, we have the detainees color. They should differ from the person. The color should differ from the person visiting them, or especially the marks or the writings in the shirt or the uniform of the person detained. Number three, prohibition on the use of possession of camera, video equipment, cellular phone, and similar devices. Okay, that is prohibited. Camera, video equipment, cellular phones, and similar devices. So before you enter those facilities, you should put them outside. Okay, that is for number four.